This week on Eye on the Clarence.
My name's Ian Gaillard. I live in the Keerong Valley. I got interested in this whole situation when Arrow Shell PetroChina drilled an exploratory drill 3 kilometres upstream from my farm, where I breed horses with my wife, and we suddenly on a floodplain, and we suddenly started investigating this whole thing. We looked further into it, and for about 17 months with a number of people, we've been exploring this whole thing that is coal seam and unconventional gas in the Northern Rivers and elsewhere. So I'm the MC for tonight. You'll see a bit of me. And this is, it's a book called Eradicating Ecocide. It's a new term, but it's one, if we reflect a little, then we know that ecocide is something that is happening in our community, in our environment, in all levels, and governments aren't keeping up with it. And the promo says, exposing the corporate and political practices destroying the planet and proposing laws needed to eradicate ecocide. And we have a message from the author of this book in London for us. We're standing with you, as many others are around the world, on this great journey to end ecocides like the fracking taking place in Australia. We are one team, one people, standing for what's right for us and Earth. Together we have the courage, the vision and the spirit to make this a thing of the past and create a future. Love and hope from Polly Higgins and Eradicating Ecocide team in London. Our next speaker is someone who a lot of you, I'm sure, will be very interested in. Sue Higginson is a senior solicitor at the Environmental Defenders Office in Lismore. I don't know how they got it mixed up. They got Clive Palmer as a national treasure, you know. They got it wrong there. They should have got Sue. Here's Sue.
That's very, very nice. Thank you. All right, so I work for an organisation. I'll just very, very briefly let you know that the Environmental Defenders Office is a community legal centre. We specialise in public interest environmental law. If you want to know what that really means, I can talk to you about it later. But I was asked to come along and talk about landholder rights. When I think really deeply about how long that would take me about coal seam gas, it would probably really be all of about 3 minutes. So I'll try and spread it out a little bit, and you'll see what I mean as we go. So basically, the very basic premise of the law that relates to coal seam gas in New South Wales from a landholder's perspective is this: you do not own the petroleum under your land. The petroleum under your land belongs to the Crown. So when we say the Crown, that's the, in theory, it's meant to be the New South Wales government on our behalf, as in the people's behalf. Companies that are granted a petroleum title, so you've heard the words tonight, exploration, production. Exploration and production in New South Wales happens under what we call a title, so a petroleum title. So it's an exploration title or a production title. Basically, companies that are granted a title, a petroleum title, they're then granted an entitlement to go and access the petroleum that's underneath the land. So whether that's your land or, as we saw earlier on a picture, whether it's our public land, our state forest. So really, if we're looking at landholder rights, and of course in New South Wales we have rights are based in a kind of hierarchical system of there are rights that will have a higher order or a higher right attached to them than other rights. So basically the way that the New South Wales law applies to coal seam gas and landholders in New South Wales is that my summary and my assessment, which is coming from an analysis of the current law, that is that landholders' rights are ultimately subservient to the rights of the company when it comes to their right to explore what's beneath the surface of your land. So there's a couple of rights that take some precedent over that once we get beyond that bottom premise that that right to explore the resource is the primary right. And that is that if you're a landholder, you have the right not to have a coal seam gas operation on the surface of your land within 200 metres of your home or within 50 metres from your garden, orchard, or some other improvement on your property. Now, interestingly, it would appear that any improvement on your property that you intend to rely on to have no coal seam gas operation within 50 metres of must have predated the grant of the exploration title. Now, bear in mind, you don't know necessarily as a landholder when an exploration title is granted over your land anyway. That's just something that happens between government and a company. We have now recently, very, very recently, got a change to the procedure, and that is when a company does now apply for an exploration lease, and we call them PELs, Petroleum Exploration, licence, not lease, a PEL. When a company now applies for a PEL, the New South Wales government has been kind enough to require that now gets put in a newspaper, advertised in your local newspaper or the land, and you're entitled to now make a submission to that. So that's the New South Wales government is telling us that's a significant improvement to your rights as a landholder. You can now make a submission when a company applies to have a petroleum exploration licence over your land, and obviously the larger area of land it applies. So the other right you have as a landholder is that there is to be no mining on cultivated land without the landholder's consent. And again, it's cultivation it's land basically that is being in cultivation for a period of time and is legitimately used for cultivation. So the other right that you have, and I suppose really this is the premise of the right that we're hearing about now throughout New South Wales, where we have petroleum exploration licences, and throughout Queensland, and that is that you have the right to negotiate an access agreement. That right basically begins with you have a right to negotiate an access agreement with the company. So say tomorrow a company decides that they would like to come to your property and sink an exploration well. The first that you're likely to hear about that is someone will come and either knock on the door. If you've got a big lock the gate sign, they might feel like they need to approach you by mail rather than walking up your drive and knocking on your door. If you get a letter in the mail from a company and it says that we have an intention, we would like to put an exploration well on your property and we would like to enter into an access arrangement with you, and then basically it says you will have some days to contact us in order to start that negotiation. So that's likely the first that you would hear from a coal seam gas company that holds an exploration licence over your property when they've narrowed down that it's your property they want to come and have a go on. So basically, if you don't negotiate with the company, or you negotiate with the company and you're not happy with what you're negotiating, the company has a right to take you to an arbitrator. So there is a specific process and an appointment of a panel of arbitrators. So an arbitrator might be appointed to your particular negotiation. The arbitrator is charged with the responsibility of trying to make sure you and the company come to a conciliated agreement. So you and the company have a kind of facilitated negotiation process before an arbitrator. If the arbitrator genuinely believes that you just are not going to come up with an agreement with the company, then the arbitrator has to impose his or her agreement on you as your landholder, as the landholder and the company. So basically what you're doing as a landholder, as negotiating an access arrangement, the law says that a company can't enter your land without this access arrangement. But then what the law does on the other hand is it says it will impose an access arrangement on you as a landholder if that's the decision of the arbitrator. In New South Wales, what we don't know at the moment, and what we haven't really had an arbitrated agreement in New South Wales that has then done the final level of appeal, and that is go to the New South Wales Land and Environment Court. So if you're a landholder, you have locked your gate, you have said to the company, go away, I am not going to have coal seam gas on my property. You've been forced to an arbitrator. You've put every real argument and real concern and genuine concern you have as a landholder to an arbitrator, and an arbitrator imposes a decision upon you, which is an access arrangement, which considers lots of matters. Those matters would be the access routes, so the way the company accesses your land, what type of activity is permitted. So at the moment we know that would be an exploration activity, so a well with a drill rig that comes for a period of time taking samples out of your land. And bear in mind, I'm talking exploration only at the moment. The access arrangement would discuss the times in which a company can enter your land, access can be granted, that there could be logbooks that are required for the entry, so the recording of when people are on and off your land, the mining company's responsibilities, any OH&S provisions, which incidentally, just as a lawyer, they're now known as WH&S, so that's work health safety, anyway, so. Indemnities, so any indemnities that there might be for the company, insurances, any environmental protection measures that you've requested or that the company has suggested, the legal costs that might fall in the result, as a result of any action under the access agreement, dispute resolution processes, the duration of the agreement, which is a very, very important clause, the manner of varying that arrangement or that agreement, including the grounds on which you can terminate an arrangement, and what sort of compensation will be paid to that landholder. So ultimately, they're the things that an arbitrator will determine with you or will impose upon you. If a landholder is completely unsatisfied with the arbitrator's agreement, then you can appeal back to the arbitrator and say, I'm not happy. And if you've got certain things you want to change or tweak, you can certainly do that. However, if you're the landholder that says, no way over my dead body, your last and final stand under New South Wales law is to appeal to the Land Environment Court. The Land Environment Court has a particular jurisdiction for hearing mining warden issues, and coal seam gas falls under that. The Land Environment Court has the final say. There's no avenue of appeal to any arrangement that's imposed upon you as a landholder from the Land Environment Court. And obviously, look, what I've tried to impart here, with no doubt whatsoever, is that the rights of a landholder, because that's what I was asked to talk about, are incredibly, incredibly limited and absolutely, in my view, subservient to the rights of a company that has the grant of a title, a coal seam gas title in New South Wales. Now, for that position to change, the law needs to change. Now, the EDO, the organisation I work for, we have written submission, we've appeared at the inquiry, and we have advocated for significant and serious law reform that changes this position significantly from what it is now. But, you know, I mean, we're one voice, and we would be saying, cheers. And look, the other thing I will tell you is the EDO, the other thing we do is we litigate. We go to the Land Environment Court. At the moment, we're waiting on a judgment because we challenge the entire Gloucester coal seam gas basin project there. We're waiting for a judgment on that at the moment. We challenge that on the grounds of, you know, future generations, the precautionary principle. We're challenging it on the big, big legal notions that we can have a go at, which is what we're saying the current law ought to actually reflect. And clearly, What we have, and I said it tonight on Channel 7 News Tonight, is what we have is a law that has allowed the companies, the coal seam gas companies, to race ahead of the thought of landholders and the environment. So that is, I would be saying that is quite a conservative legal critique, but that is the critique we have. So one really good news story in terms of lock the gate, the law and arbitration that we haven't yet seen is one petroleum exploration licence area just south of Moree. It's quite a small one, and it's this one here. This little Pell 470. The landholders in that Pell, the company has knocked on a number of gates, and it has issued a number of notices to landholders in that Pell saying, we want to come on and we want to explore. We have to put an exploration well on a property within Pell 470 very soon, or else we're not fulfilling our obligations under our licence as a company. And basically, everyone in that Pell has locked its gate, and every time the company goes knocking on those gates, those landholders say, not us, take us to arbitration, we're ready. So what that Pell has done is it's got together, it's got a fighting fund, so it's putting money in a fund ready for when the one person in that Pell is the one that's picked on to go to arbitration. So look, the take-home message from me, and I'm happy to answer questions later, is that right now the law is not your friend as a landholder, it's not your friend as an environmentalist. The law is not designed to protect the environment. The law is designed, as I said, the very, very bottom premise is you don't own what's below your land, that the Crown does, and that companies are granted entitlements to take it. So that's what I would say for this evening. Cheers.
Right. My question's for Sue Higginson. Sue, you were talking about the Pell, whatever it was in Moree, where everybody has locked the gate. But somewhere along the line, somebody mentioned that there is a time limitation for these companies to do their exploration. How long is that time?
The exploration licences can be granted for 3 years normally, but anywhere up to 5, 6 years, and they can be renewed. And really interestingly about that is that if you are a company, you haven't quite fulfilled all your obligations under your exploration licence, you apply for a renewal, then if you apply within the right time, which is about a month before it expires, then the law says that you can just you can carry on until the government either grants you a renewal or refuses you. In fact, at the moment in New South Wales, we've got a lot of expired Pells around the place, or quite a number of them. All of those companies, to my knowledge, have sought renewal applications, and the government's sitting on them. So at the moment, it's business as usual under expired petroleum exploration licences.
So is it an option for a community to apply for, to take out an exploration licence for their own area, like as a way of stopping other companies taking over? Is that...
The way the current law is, I would have to say that it's highly unlikely you could do that, because to be able to access a Pell, you have to, it's like what we would call a show cause. You have to show that you're a company in the business, you have expertise, you have the financial backing that basically deems you eligible. So if you're a community and you didn't have all those things, then you would be deemed not eligible.
My name's Steve, I'm a local resident. It was mentioned earlier about getting in a situation where you'd end up in the Land and Environment Court. Why wouldn't you seek that out? Turn the tables, go on the offensive and take them to the Land and Environment Court?
So the only way you can take the company to the Land Environment Court, the process is stipulated under the law. So it would be hard to have a cause to take them to the court unless they had come to you for an access arrangement, you denied it, the arbitrator enforced one upon you, and then you appealed. That's the avenue. Like, bear in mind, every court has a door, and when I say a door, I don't just mean the physical door. There's a particular path and a particular door, and unless you have the right key and the right path to walk on, it's, you know, that's what it means to get to a court. Like, as people, we don't have necessarily standing to just walk in and say, this company can't come on my land. You know, you would have to show that that company wants to come on your land, and in fact, in the Land Environment Court, to get there, you'd have to have had an arbitrator's agreement enforced upon you, and then you can appeal that. In terms of other courses of action to the court, I'm not really sure of one that would be open and available.
Right, thank you. Is there a place at all in this whole process for the High Court?
The way I see it, I would argue that at the moment, not really, because the way the system works, so the New South Wales government, the highest court in New South Wales is our Supreme Court. Now, to go to the High Court, it would be, basically the law says the New South Wales Land and Environment Court, whatever decision it makes about your access arrangement, is the final binding decision. The High Court wouldn't be able to have jurisdiction over a matter relating to a land access arrangement that the Land Environment Court had determined. If there was a question about, you know, the constitutional validity of the petroleum legislation, then okay. But that in itself, the merit of that, I would say no, there's no merit to that argument at the moment.
Thank you, Lance Flemings. Question possibly to Drew and Sue. Just fundamentally, to be able to protect our property, I'm just concerned about just sort of geared to guesses. I don't know, with freehold property, as far as I'm aware, that on the title, it's got, okay, we own the property, however, it excludes our right to petroleum and minerals. Has everyone here got the same thing on their titles? Pardon? Yeah, well, just on the freehold titles that I've had, fortunate to have had in the past, it always excluded petroleum and minerals. I'm just wondering about, it just seems to be geared against us. How are we going to actually protect our land and fight that, and how do we get it overturned? I mean, it's, you know, that's my question. Is it obviously a very difficult one, I think, to overturn on our titles, because we've all been aware of it when we've been granted those titles.
Well, look, I mean, I would say that's exactly right. That is the fundamental premise, as I said, to the laws that we have. What gives them their very validity is the traction that that notion has, and that traction resonates through the entire legal system. So, as we know, the very basis of our legal system is that, you know, private property is sacrosanct. However, what's below it belongs to the Crown. And the reason, the rationale, I suppose the underlying ideology to that is that it was always seen that those minerals are exploited for our benefit by the Crown. So the argument I would be saying at this point, trying to be a creative lawyer if there's such a thing, is that the community is saying it's not to our benefit, and therefore the New South Wales state constitution that we have, that gives the New South Wales Parliament all of its kind of powers to make laws, it says for the good governance and for the good of the New South Wales people. And we are saying, or the New South Wales people are saying, that, well, right now the Petroleum Onshore Act is 100% not for the good of the New South Wales people. So, I mean, there are arguments in there, but ultimately, regardless of what's on your title, what gives the companies the power to do it is that one piece of legislation. So if that changes or that doesn't exist, there is no system of laws for the companies to exploit that resource. So whilst you don't own it, that's something in and of itself. What the problem is, or I see with the legal system, is the laws that just grant the carte blanche attack on or ability to extract that resource to the detriment or of anything else, or to the oblivience of anything else.
Lock the Gate has decided quite a long time ago not to challenge that whole notion that the minerals beneath the surface belong to the state. But what we do challenge, and Sue's basically just said this now, what we do challenge is the completely inequitable relationship that exists between the mining companies and the landowner. At the present time, mining companies can, with varying degrees of difficulty, come onto your land and conduct their activities. We're wanting to right the balance of that. And look, it's not the same in every state. In WA, landowners have the right of veto. They can stop mining companies coming onto their land. And I haven't noticed mining shrivelling up and dying in Western Australia. They just simply come to a more equitable commercial arrangement with the landowner to come onto the property or to buy the property. So that's what we're saying. There should be, I'm not quite sure how, we haven't done a real study on how you change the law, how the law needs to change, because the state and the community at large does have a stake in the whole thing. But at the present time, it's weighted far too heavily in favour of the mining companies. It needs to be righted in favour of the landowner.
And in terms of ownership of the mineral and petroleum resources under your property, we could look at what's happening in the eastern United States. Gasland is a movie that comes from the eastern United States, where the property owners actually do own the gas under their properties, and people aren't happy. They're getting hundreds of thousands of dollars in compensation. It's not enough when you've stuffed up your water.
Hi, I'm a local resident from around here, and I just wanted to know, say if you've got a woman or somebody living on their own on the property and the mining companies bully them and it ends up in court with the arbitrator, who pays for all that? Does the landowner get any compensation, or if they have to go to court?
There is, so in the first instance, if a mining company comes to you and you say, I don't want to talk to you without having first got legal advice, then they are meant to provide you some money. So if you go and get legal advice in the first instance, they will pay your reasonable legal costs in the first instance. If you're going to take it further, then it's likely that ultimately it's likely that you will bear your own costs if you're going to take it further. If it goes to arbitration, the laws are written that the company has to pay for the arbitration, as in not your costs, but the arbitration costs itself. And very interestingly at the moment, if you go to court, I'm really not sure how the costs work, even in terms of, sorry, I'm probably going one step now further than the question, but I'm not actually sure, and it's not clear, and we've kind of asked a question really of the mining warden's jurisdiction, the Land Environment Court, whether if you take a company to the Land Environment Court because you're appealing the arbitration, if you fail and the arbitrator's agreement is upheld, are you, as a landholder, responsible for the company's legal costs because ultimately you lost? There's actually a real question there at the moment. So in terms of the inequities that Drew's talking about with kind of landholder rights, that question too is actually a little bit unanswered at the moment, and it's certainly something the EDO is trying to seek clarity on at the moment, because the way the law is written and the way I read it, it says the costs follow the cause. That means the loser pays the winner's costs. So it is a really interesting question at the moment. It's one that's really got up my goat, so I'm trying to find the answer out.
I think it sucks too, but thank you for answering the question.
Thank you, Marilyn.
Yeah, g'day, my name's Terry, I'm a Grafton resident, and I just wanted to ask a question of Sue, really. It sounds from what you said before that there's some sort of a contradiction between the legislation that allows miners onto your land and the constitution which says for the betterment of New South Wales. Now, it is for New South Wales residents, is it anticipated that there'll be a legal challenge to set some sort of a precedent in this regard?
Okay, so just one thing, and I'll just clear one thing. When I talked about the Constitution, what I referred to was the Constitution Act of New South Wales. So I wasn't talking about our Commonwealth Constitution, because the way the system works is in New South Wales government controls the New South Wales environment, let's say. So, and mining is dealt with by, and coal seam gas is governed by the New South Wales government. And at this point in time, oh dear, am I getting feedback? No. At this point in time, the short answer would be no. I don't know of any argument that would have enough merit, that would experience enough prospects of succeeding, because, as someone said earlier, while we may be in a room of people that understand that, you know, the consequences of coal seam gas right now are probably very, very detrimental to the environment, what we also are dealing with is a community and a government and policy that thinks that coal seam gas extraction is in the interests of the New South Wales community somehow, because it will be raising revenue. It is like the way we see mining, and that is we take these resources out, we get royalties, even though we've learnt that we get very, very little over a very long period of time. But at the end of the day, there is still that argument that it is for the better. It's meant to be, the intent is that it was meant to benefit the New South Wales community. So at the moment, I would have to say I would not be able to run a case like that, because I just wouldn't have reasonable prospects of succeeding in a case like that.
Thank you very much.